right, so why are you beating up on a 14 or 15-year-old? And you came up behind her, pulled her by her hair, dragged her by the hair, and punched her. So I'm trying to figure out, why are you hitting on a 14-year-old? So are you saying that this is just all made up?
Oh gosh.
There's a video, according to the police report.
I know there's a video. I know it's a blurry video. I know it looks like me.
Yeah, it's saying that you pulled her hair, you beat her up.
Yeah, I'm aware of what she said I did.
Alright, so today we've got a defendant who walked into court acting like she's the smartest one in the room, chin up, cigarette confidence, and zero remorse. But what she's about to find out is that the judge does not have patience, and today's lesson might come with a side of jail time. The tension's thick, and you can just feel the courtroom realizing that this woman isn't nearly as tough as she thinks she is. It's wild how people can justify violence in their heads until they're sitting under fluorescent lights, trying to explain it to a judge. This isn't a TV episode, this is real life, and the stakes are about to hit hard. And when the judge starts digging into her reasons, you can practically see her brain buffering. Think she's still feeling smug? Let's go ahead and dive in and watch.
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison? Counsel, has your client been able to provide you with any defenses?
She has.
Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is recommending deferred adjudication. There's an affirmative finding of family violence. No contact with Ariana Garza. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
Next, I'm showing you outside the agreement. The state is recommending that your community supervision be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State offer states one and attachments.
We did review them, no objection.
Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
Sure.
Anything you might want to say on behalf of your client?
Several things. She's 33 years old. This case happened about 3.5 years ago. Since that time, everything's been perfect. It's happened to be the girlfriend of her son, who she thought was leading him down the wrong path. Certainly not handled correctly, but the boy does not date or see the girlfriend anymore. Mom has not seen this girl since that time. She does have full-time employment as a night auditor at a local hotel. She is gainfully employed. She does other side work with other groups that she can tell you about if you'd like to hear, because I'm not familiar with the groups that she works with.
So how old was your son's girlfriend?
At the time, my son was 15, so I was swimming around 14, 15.
All right, so why are you beating up on a 14 or 15-year-old?
I'm not the one who did it.
I'm sorry, what?
I didn't. I've never seen this. Like, I've seen the girl in person, but I've never.
Now, according to the police report, what you just pled to, she was walking with your son in a park and you came up behind her, pulled her by her hair, dragged her by the hair and punched her. So I'm trying to figure out, why are you hitting on a 14-year-old? I'm sorry, what?
I mean,
There's a video, according to the police report.
It's. I know there's a video. I know it's a blurry video. I know it looks like me.
So are you saying that this is just all made up?
Oh gosh.
No, if you want a jury trial, we will give you a jury trial.
I mean,
How are you going to be in your 40s and beat up a 14-year-old girl, your son's girlfriend, for literally dating him? That's not protective, that's delusional. She's sitting there mumbling through excuses like she's trying to invent logic on the spot because deep down, she knows there's no good reason for what she did. And the fact that she's caught in 4K doing it makes it even worse. There's no maybe, there's just reality. What really gets me is her attitude, puffing a cigarette like she's on break from her own trial, smirking like the whole thing's just a misunderstanding. You can't act chill when you're this far gone. The judge's face says it all. Pure disbelief mixed with restrained fury. She should have practiced some answers the night before because walking in this unprepared is almost self-sabotage. The court doesn't like silence when it's your turn to speak. It reads as arrogance, not nerves. It's like she thinks if she stays quiet long enough, accountability will just pass her by, but it won't.
I don't want it to go bad and make it, and I go to prison for something I didn't do.
Well, here's the thing. If you're saying you didn't do this and you want a jury trial, then guess what? In the 187th, I will put cases to trial and we will give you your jury trial. But what I'm reading in the police report, there is a video. And yeah, it's saying that you pulled her hair, you beat her up.
Yeah, I'm aware of what she said I did.
So your only question is, do you want a jury trial or not?
I don't want a jury trial.
All right. So then we're back to the point. Why are you pulling on a child's hair?
So no, I was angry. I was really, really upset. My son wasn't going down any wrong path until he met this girl. They were doing drugs. He was running away. He was stealing cars. I was just trying to be a good parent.
Well, I mean, how is it a good parent to beat up somebody who's dating your son? Why do you think that she's in charge of your son's actions? Did she put a gun to his head and say, do these drugs with me?
She told my son she was pregnant.
All right. Then people need to start supervising their children better.
That's true.
I'm going to sentence you to 6 years deferred adjudication. There's an affirmative finding of family violence, no contact with Ariana. That's Ariana Garza. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular UAs. No unsupervised contact with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once she's completed parenting classes, that will be deemed satisfied. There's to be field visits. State versus Angel Montoya. Can I have parties announced for the record for the state?
For the state of Texas.
For the defense?
Attorney Bill Simmons for defense.
And are you Angel Montoya?
Yes, ma'am.
Did you review the document entitled State's Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Community Supervision?
Yes, ma'am.
Are you the same Angel Montoya who's placed on deferred adjudication in 2022 CR 0054 for the offense of injury to a child bodily injury on February 13th, 2024 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Office states supplemental pending motion to enter adjudication of guilt and revoke probation. Violation condition number 4. In Bexar County, Texas, the defendant, Angel Montoya, did then and there fail to report to the supervision officer as directed for the months of April, May, and June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
I'm sorry?
True, sorry.
Additionally, Your Honor, on the state's original motion to enter adjudication of guilt, state will waive all of those violations.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, and
Yeah.
that is for the motion to be denied to allow the defendant to apply for felony drug court. Should she be accepted to that, then fine. Should she not be accepted to that, then alter and amend conditions of her current probation to add SATIF, followed by SATIF aftercare.
This might be one of the most clueless defendants I've ever seen. The judge asks her direct questions and she just sits there, blank stare, zero remorse. It's like she showed up to court waiting for applause that's never happening. Then she drops the "I was protecting my son" excuse. Please, you don't protect your kid by attacking another kid. That's not love, that's control. The judge saw right through it and you could literally watch her confidence collapse. That fake smirk vanished the second 30 days in jail came out. That's when reality finally caught up. All that fake calm, gone. The system doesn't care about excuses, only actions, and she just learned that the hard way.
All right. Why isn't she reporting?
Your Honor, is the court inclined to hear the testimony? Because I have one witness as well.
Yes, I want to know why she's not reporting.
If I could, and then we'll call her, Judge.
Sure.
But if I could call Leslie Banderas.
Right. Hello, could you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Leslie Banderas.
All right. Counsel, you may proceed.
Ms. Banderas, how long have you known Ms. Montoya?
All right.
All her life. And you're familiar with her legal situations that she's been involved with, correct?
Yes.
Okay. And you've got a unique knowledge of that based on some of the organizations that actually, community organizations, the numerous community organizations that you're involved with, correct?
Yes.
Like, what are some of those organizations?
I have an organization, it's called Homies and United Network.
Mhm.
How we deal with the formerly incarcerated and their families, like, providing resources or guidance into the right direction.
And the reason I'm asking this is that so that you have some understanding of Ms. Montoya's, what she's dealing with.
Yes.
And so you admit you deal with the formerly incarcerated.
Yes.
When she got out, she was on a parole, is that correct?
Yes.
And but she did. Bottom line, you deal with a lot of people in these situations, correct?
Yes.
Would you say that she was putting her best foot forward to try to be in compliance with her parole and the new probation that she had received?
Yes, from what I saw, she was completing, going to classes, and correspondence with her probation and her parole officer. We were even getting visits. She was getting visits to homes. So she, as far as I know, they were good visits, as far as I'm going over there.
I'll pass the witness.
Any questions?
Just a few questions. I'm sorry, I didn't catch your name.
Leslie Banderas.
Ms. Banderas?
Banderas.
Balderas. And how long did you say you've known Ms. Montoya?
I've known her all her life.
All her life. So since you were children, you guys grew up together, I guess?
I'm her mother.
Oh, you're her mother. I'm sorry. I didn't hear that part too. All right. So you being her mother, are you aware of the issues she's been having with substance abuse?
Yes, I've been aware as far as what she was, I guess, smoking.
Okay. To your knowledge, how long has she been using drugs or smoking, as you say?
I'm not even gonna lie to you. When my kids didn't even start messing up their life after they moved out of the house after the age of 18.
Okay, so
She's always I've never had problems with her in school, anything like that. She graduated.
Yeah.
Even had a scholarship to go to college.
Mhm.
She was good. So
all right. So after adulthood is when these issues started to come about.
Sorry to interrupt. Sorry to interrupt. You're recommending that she be continued?
Correct.
All right. So here's my question for her. Either she wants to be on probation or not. She's not going to be released today. She's going to SafeP. If she doesn't want to go to SafeP, then she's going to be revoked.
I believe the recommendation was SATIF, or no, safety.
It's SATIF, but based upon the stipulations that were entered into and what she did, obviously there are major drug issues, and this is more than just, I think, can be taken care of by SATIF, because let me just tell you the reason why I say that. She's looking at 10 years in the prison. She has some choices to make. Either I use drugs, and potentially could go to prison for 10 years, or either I don't. And she made the choice. I'm going to use. So that tells me that her thought processes are not where they should be, and that she's in the throes of her addiction. So I'm going to give her a choice of whether she wants to be continued on probation and go to safety, or whether she wants to go to prison.
What is that, CFP?
It's an inpatient treatment facility at the prison.
Oh, at the, do they provide housing? Because me,
Yes, they
you know,
do.
what, like I said, the organizations that we do, we just feel, you know, they need help regardless of what.
No, they're gonna give her help.
Regardless of what the case is, you know, every individual needs help.
No, they're going to give her help if she wants it. So let me have you step back, and I'm going to ask her what she wants.
Now it gets darker. She's got her own substance abuse problems, but claims she attacked her son's girlfriend for being a bad influence. That's hypocrisy on full display. You can't warn someone about addiction while drowning in it yourself. The judge caught that instantly. This wasn't punishment, it was a mirror. Every question was basically, what are you doing with your life? And you could see her shrink under that truth. Substance abuse court can fix you, but not if you laugh through it. Jail or rehab, one of them saves you, one of them breaks you. The question is, which one will she choose?
And Your Honor, would that, so we're saying that there's no option for her to at least be interviewed by a felony drug court?
Felony drug court is probably not going to accept her. I'd say 98% because of these charges and the underlying facts that are in these stipulations. So you have a choice. If you want, and these are your only two choices, there are no other choices. So there's no third choice. One, I can continue you. I will continue you and sentence you to safety. Or two, I will revoke you and sentence you to 5 years in the prison.
Okay, but that interferes with my parole that I'm already on. And I'm good on parole. I go to all my classes, I pass all my drug tests, even some of the drug tests that I've come out negative as far as on probation, I've passed on parole. I'm getting help. I go to behavioral therapy, I go to therapy, psychiatrist, I'm on my depression, anxiety pills and everything like that. I'm on a mood stabilizer now that I'm in Bear County. Like
See, these are things that people need to do when they're not in custody.
I was doing that before custody. I have proof that I was doing that before custody. I went to university. I got into behavioral classes. I got into therapy. When I went to my TAP evaluation, I asked for the intensive outpatient drug course because I told her I felt like I needed the help.
And if I may, Judge, we did verify that with probation. She was only one class away from intensive outpatient, but I think the big thing is that they wrote her glowing reviews. They said she was doing a very good job. That's in the notes. It's also reflected in the court summary.
Any objections to the court reviewing the court summary?
No, Your Honor. No mistake.
All right. In reviewing the court summary, it says that once she just found out she had a warrant, she didn't report anymore.
Yes, Your Honor, I believe, but it's also under the, if I could see it. What I was just specifically referring to was in their justifications. Just that specific language about.
All right. So what I'm telling everybody.
Their great attendance in the IOP program.
All right. So this is what I'm telling everybody. They 99%. There's a 1%, maybe they'll accept her in the felony drug court, but there's a 99% chance they are not. What I'm telling you is she has a choice. If she would like for me to revoke her, I will sentence her to the 5 years. If not, then, I'll send her to felony drug court, but I'm telling you, felony drug court is not going to accept her. There's a 99% chance they won't accept her. If they don't accept her, she's going to safety. So those are the choices. There are no other choices.
Yeah, I understand this.
So, can I have 30 seconds, Judge?
Yes. Counsel?
Yes, Your Honor. If we could, about how long do we think the felony drug court referral would take? Because
They'll probably have it done by next week.
Because there's some questions to ask in terms of whether or not the safety would result in her parole being revoked, because it's treated as if, and I would ask the court too, it would be treated as if she's being sent to prison, which would revoke her current parole. That's a question that I would like to know, because I'm not putting at the front of my thoughts. I'm not sure if that's true.
If that's true and it results in that, then
Yes.
we can always bring her back. All right, the court is finding violation of condition number 4 true. Court would deny the motion alternate men conditions to include in custody, a referral to felony drug court. If not accepted, then safe P.
Wow, that was a mess from start to finish. We had a mom in her 40s beating up her son's teenage girlfriend, somehow ending up in felony drug court, and still acting like she's the victim. It's wild. She's old enough to know better, but acting like she just learned what accountability means. The irony is brutal, trying to raise a son while clearly struggling to raise herself. This kind of behavior doesn't just hurt families, it clogs up courts with cases that shouldn't even exist in the first place. What stood out to me was how the judge handled it. Fair, firm, and tired of seeing the same cycle repeat. Do you guys think this was a wake-up call that will actually stick, or will she go right back to the same old habits once the spotlight's off? Because if she doesn't change now, next time it won't be 30 days, it'll be years. Let me know your take in the comments. Thanks so much for watching, and I'll catch you in the next one.